Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Yesterday we talked about a case that the Ninth Circuit got right, the Snitko case. But today we have to talk about three of them that they've gotten wrong. Now, they're all on the same theme, so this will be fairly easy to do, but I want to preface it by starting where we have to start when we look at constitutional cases, which is, oddly enough, the Constitution. In this case, it involves the application of the Eighth Amendment. And everybody knows generally what the Eighth Amendment says, but let's look specifically at what it says. It says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So just looking at this, we can tell a couple of things. The first part of this amendment, excessive bail shall not be required, relates to pretrial detention. While there are a few off cases where bail is granted after a conviction to allow an appeal on a particularly close issue, normally bail is a pretrial right, and normally it's a right where you absolutely have a right to bail, except in certain cases. And the more severe the case, the more likely it is you're not going to get bail. So, for example, when Charity Winter was sort of accused of basically treason for, violating the sanctity of the National Security Agency and releasing classified information, well, that was pretty severe and she didn't get bail. Similarly, anybody who's accused of murder is not going to get bail usually. And that's a good thing. We want to protect the public. There is a balance in the first part of this that goes like this. We try to protect the public with a bail amount that we know is going to make sure that the person who did the crime will show up and be accountable in court. Now that's why when somebody has a great deal of wealth, we require a great deal of bail. We have to make it painful for them to lose enough money for them not to skip out on bail. Then, nor excessive fines imposed. That has to occur after conviction. In other words, you don't impose a fine before you find somebody guilty. Nor cruel and unusual punishments inflicted. Again, something that happens after a conviction. That's important in terms of the overall discussion of where we're going with the Eighth Amendment in this case. So there are three cases. One of them is Martin versus City of Boise. That's the first case. The second is Johnson versus the City of Grants Pass, Oregon. That's the second case. And the third one is the Coalition of Homeless Against San Francisco. That's the most recent case issued by the Ninth Circuit on this subject. And if I had to just distill the gestalt of these three rulings, here it is. If you are homeless, you have an absolute right to sleep anywhere you want that is public property. So you can sleep in the post office, you can sleep on the sidewalk, you can sleep in the city park, you can sleep underneath the viaduct, you can sleep anywhere you want as long as the city doesn't have a homeless bed for you. If the city or the county has a homeless bed that they can put you into, then you can't do that. But if they don't have sufficient space to house all of the homeless, then you can do whatever you like, and they can't enforce it against you. They can't arrest you. They can't fine you. That's pretty broad. The United States has always had anti-vagrancy laws. In fact, when I was a respiratory therapist in West Palm Beach, Florida, one of the things that really got the people there upset was the fact that the people up north, particularly in Massachusetts and New York, would gather up their homeless starting about November 1, when it started to get good and cold up there, and they would issue them a train ticket down to West Palm Beach, Florida. And they would take the train down to Florida, and then they would become homeless in Florida. as far as this case goes, which is only good in the Ninth Circuit, a city that has an anti-vagrancy ordinance or an ordinance regulating its city parks or its county parks cannot enforce that against the homeless because it is, quote, cruel and unusual punishment. This does seem to fly in the face of Eighth Amendment jurisprudence. So Martin versus Boise was the first case. The second case was Johnson versus Cities of Grant Pass. And when that case was decided, they asked for Onbon review, which is where all 27 judges of the Ninth Circuit get together and decide whether or not to rehear the case. And they decided against rehearing the case, and this is what one of the judges, Smith, Circuit Judge, Callahan, B., Ikuda, Bennett, and Nelson, all joined in dissenting from that denial. And here's what they said. In one misguided ruling, a 3-judge panel of our court badly misconstrued not 1 or 2, but 3 areas of binding Supreme Court precedent, and crafted a holding that has begun wreaking havoc on local governments, residents, and businesses throughout our circuit. Under the panel's decision, local governments are forbidden from enforcing laws restricting public sleeping and camping unless they provide shelter for every homeless individual within their jurisdictions. Moreover, the panel's reasoning will soon prevent local governments from enforcing a host of other public health and safety laws, such as those preventing public defecation and urination. Perhaps most unfortunately, the panel's opinion shackles the hands of public officials trying to redress the serious societal concern of homelessness. Well, when a judge writes that kind of blistering dissent, it has some teeth. And apparently, when this case was petitioned for certiorari, somebody in the Supreme Court read that dissent and thought, this doesn't sound like our Eighth Amendment jurisprudence. So let's talk a little bit about prior Eighth Amendment jurisprudence. In the case of Furman versus Georgia, the Supreme Court held the death penalty was unconstitutional as applied. Now, it later retrenched from that position, but basically it said that as it been applied in that case, which was discriminatorily, it was unconstitutional. And as I said, eventually they retrenched from that position after there were certain procedural reforms in death penalty cases. But in one famous case, Harmelin versus Michigan, it was a 1991 case, the Supreme Court ruled that the Eighth Amendment's cruel and unusual punishment clause allowed a state to impose a life sentence without the possibility of parole for the possession of 672 grams of cocaine. The defendant, Ronald Harmelin, directly asked the court to extend the reach of that analysis to non-capital cases like his. Although 5 justices agreed that his sentence was not unconstitutionally cruel and unusual, in fact, Justice Scalia said it was cruel, but hey, it wasn't unusual, 6 justices agreed that the cruel and unusual punishment clause bore some kind of proportionality analysis. So the case was affirmed, and it's fairly obvious from both the way that the law has changed since Furman, as well as Harmelin, that SCOTUS is not exactly all warm and fuzzy on the Eighth Amendment. Now, in spite of that, there are certain requirements for punishments. They cannot be excessively severe. Punishments that are disproportionate to the severity of the crime committed may be considered cruel and unusual. For example, a murder committed at the age of 15 when a kid's brain is still developing, well, that was thought to be a cruel and unusual punishment. And as a result, you can't sentence a teenager now to life without parole. You have to give them life with the possibility of parole if they commit a murder. Also, punishments cannot be inhumane. So if they involve torture or barbarity or unnecessary suffering, they're cruel and unusual. The recent punishment of a death row inmate in Alabama with nitrogen gas caused him to have violent spasms and thrashing, suggesting there might be pain. However, at the time, they asserted the inmate was unconscious and that it was just a normal response to hypoxia. But either way, the fact that it looked the way it did, it certainly appeared to be barbaric, and it's probably not going to be a routine practice going forward. Arbitrariness and discrimination. That's Furman versus Georgia. Punishments that are applied arbitrarily or discriminatorily, particularly based on factors like race, gender, religion, or socioeconomic status, violate the Eighth Amendment. And finally, practices that were once accepted may be deemed unconstitutional as societal norms evolve. That's a case for another day. But it's important to note that all of the Eighth Amendment constitutional cases involving the cruel and unusual punishment clause have dealt with court-imposed punishments. Now we turn to this case, which essentially said you absolutely can't do that. You can't make these people who are sleeping in a park get up and go sleep somewhere else because you don't have a homeless shelter for them. And as a result of that, the city of Grants Pass sought certiorari to the United States Supreme Court. And I want you to think about something for just a moment, and that is, if it is absolutely forbidden to put these people in handcuffs for sleeping in the city parks and that sort of thing, unless the city has homeless beds for them, is that not in effect making the right to shelter an individual constitutional right? Is that not extending the Constitution well beyond its means? We have never had a constitutional provision that said that everybody's entitled to a place to live. In fact, I would say the majority of the country believes that if you're going to have a place to live, you have to work for it. That's the reason why people build houses and why people sell houses. So, at the core of its ruling is a direction that the cities and counties are responsible for housing people who don't want to be housed in the first place, or in the alternative, you have to let them sleep in the parks. That to me sounds like exceptionally bad public policy, and that's why the city of Grants Pass sought certiorari. In fact, let's look at their petition. In Martin v. City of Boise, the Ninth Circuit held that the Cruel and Unusual Punishments Clause prevents cities from enforcing criminal restrictions on public camping unless the person has access to adequate temporary shelter. In this case, the Ninth Circuit extended Martin to a class-wide injunction prohibiting the city of Grants Pass from enforcing its public camping ordinance even through civil citations. That decision cemented a conflict with the California Supreme Court and the 11th Circuit, which have upheld similar ordinances and entrenched a broader split on the application of the Eighth Amendment to purportedly involuntary conduct. And it's purportedly involuntary because being homeless is in many cases voluntary conduct. The Ninth Circuit nevertheless denied rehearing Onbon by a 14-13 vote. The question presented is this: does the enforcement of generally applicable laws regulating camping on public property constitute cruel and unusual punishment prohibited by the Eighth Amendment? And in the certiorari petition, they make a number of arguments. Those are that the circuit's decision entrenches a conflict among the lower courts, and it conflicts with this court's, meaning the Supreme Court's decision, and the question is exceptionally important. How do we know that it is exceptionally important? We know that it's important because none other than the governor of California, as amicus curiae, meaning supporting the petitioner, helping the city of Grants Pass here, saying essentially you need to fix this problem. And in the interest of amicus, what he says is this: Governor Newsom is the governor. As mayor of San Francisco, he partnered with local organizations to help thousands of people transition from the streets to supportive housing. And he goes through all of the efforts that they've made, and the fact the governor believes strongly that helping people experience as homeless requires meeting them where they are and treating them with dignity. The crisis of homelessness will never be solved without solving the crisis of housing, as the two issues are inextricably linked. But while states and cities, counties work on these long-term approaches to help with these crises, they need the flexibility to also address immediate threats to health and public safety. And that is the key to that particular case. So the Supreme Court has this on their docket. They've accepted the petition for certiorari. I suspect it will be argued this term, and we should get a ruling. And hopefully that ruling will overrule these two very bad, I should say now 3 very bad cases written by the Ninth Circuit. But here's the thing. Every court that issues opinions gets some things right and some things wrong. It occurs at the district court level, it occurs at the Court of Appeals level, and the only place it ever gets fixed is at the Supreme Court. And that's one of the reasons why we have a Supreme Court. So that's what I have for you today. These present really interesting questions, and hopefully if you have any comments, you'll leave them in the comments down below. One thing I want to urge you to do if you have a chance today, to do something kind for someone. We've all stopped at exits and we've seen people holding signs that say, you know, we'll work for food, can you spare $1, whatever. I'm hungry, my kids are hungry. A lot of times at our local Target, we have a guy who plays his violin and his kids stand there and they're hungry. You can tell they're hungry because they're thin as rails. And I routinely give those folks money. I know that there are people who think I shouldn't do that because they're probably using it for drugs or maybe they're using it to buy beer. I don't know. That's not on me. My belief is that I have to do what Jesus asked us to do. And he said that whatsoever you do for the least of my brothers, that you do unto me. And so I believe that it's within my power to help people, and I can help people. And it may only be $20 here and $20 there, but it does some good. And how they spend it is up to them. The fact that I give it and give it freely because it's the right thing to do, that's what matters to me. You may have different opinions. Feel free to share them in the comments down below, or you can always email me at the address above. Thanks again for watching. Catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.